This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviat. Tonight we're taking your calls and questions on any legal topic. It's Ask Us Anything night on 31 Law Call, and that kind of scares us a little bit sometimes because we don't know what you're going to bring up. The 31 Law Call number 256-536-0077. So anything from car accidents, medical malpractice questions, maybe a pharmacist gave you the wrong medication, call in and ask. Also, you can email your question. You can email any legal question any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we will pull out some of your questions. We've got some of your email questions tonight. And Will League is here from Timberlake and League to help answer questions on anything from, okay, auto accidents. That's probably personal injury, guys. That's where most of us come in contact with a personal injury lawyer. Is an auto accident, and we've got questions about that. But it's a lot of things.
A majority of our cases are, a lot of car wrecks, 18-wheeler wrecks. Oftentimes you're looking at premises liability claims. You're on someone's property, medical malpractice. You don't do criminal work, but for family and friends. So oftentimes people have questions on that. Domestic relations. Sharon, in your area, people will call in, and when you talk about, the custody of children, child support, alimony, how things are going to be moving forward, those are obviously important topics. But you're right, most of our cases are medical malpractice, car wrecks, Sharon, with some premises liability, products liability. Oftentimes, it's a lot of things are moving to class actions. You hear about the Camp Lejeune,
yes,
the earplugs, all those type things. If you have a product that is placed within the stream of commerce and it's somehow defective, whether design, manufacture, it can't be. Let's say you're using a weed eater to trim your mustache and you get hurt. Has to be for the intended purpose.
Right.
How it's come up a lot of in the last few years is products liability of gun manufacturers. What is the liability if you have a gun that gets in the hands of someone who's not allowed to have one, whether it be a mental illness, whether it be a crime, convicted of felony, things like that. You see a lot of things, surrounding gun injuries, more than we used to, sadly.
We've got a video for you tonight. We always like to give you, you make the law call. We've got some video that we pulled from YouTube to show you and ask you what you think should happen in a situation like this. These folks are just walking through at a restaurant. Thank goodness this was not a crowded restaurant, but a car comes out of nowhere and slams into things, and I think we're going to have a couple of different views of it. So from a legal perspective and from somebody who does these kind of cases, if somebody is injured with something like this, if they've been hurt, is the restaurant in any way liable for any of that, or just the car driver?
Well, when you look at it, it's not uncommon these days to have video of the accident, have video of the incident that we're trying. So oftentimes when you can press a button and show the jury what you're talking about, as opposed to try and recreate it through animation or just simply trying to explain to them what happened. And so in this particular case, we do have a video. The guy's got a lot of issues going on. Let's say we got a drunk driver. He's looking at criminal penalty. He's obviously civilly, not acting as a reasonably prudent person would drive their vehicle. He's liable for the damage. It really is insurance company if he has insurance, or she. If there's insurance coverage available, the restaurant owner has a claim against him, property damage the city made to repair the sidewalk. And then when you start talking about personal injury, his insurance will cover him for that conduct. But we were talking earlier, let's say the gas pedal stuck. That car was recalled, but they didn't provide the right information, or they didn't disseminate the information to that particular owner. What if it's a liability situation, a liability claim?
What if I get one of those notices and I don't do the recall?
If you fail to follow the manufacturer prescribed recall, then you will not afford yourself with their protection, whether it be warranty, fixing the part, that sort of thing. Could that negate your insurance coverage? So let's say, Sharon, that was you in that car. It stuck. You went through and hit those people. If you got a notice in the mail and didn't go sort out that, then would you negate your insurance coverage because you failed to mitigate or lessen the damage to your particular vehicle? So that's something you have to look at. So, goodness, I've thrown away several myself, by the way. So I need to listen to my own advice.
We've got callers waiting. We've got Glenn on the line with a question from Athens, and I think he's got a Camp Lejeune question. Glenn, thanks for calling. What's your question tonight?
I was just trying to find out if there was any local attorney, any local law firms handling the Camp Lejeune contaminated water claims.
There are some guys typically he's talking about a class action suit
Yeah.
where basically some contaminated water, anybody who went through that facility who suffered any ill effects, whether it be cancer or whatever the prescribed thing. So when you look at a class action, what are the damages? You have to have a lot of people with similar conduct or similar damages to where there's so many, it makes more sense in the courts to try them all together. And so basically, you could have anywhere from 100 to 50,000 people, even more, depending on how many. You'll have a class representative that'll be responsible, and then they'll try that case or settle it, and then where you fall in that schedule of damages will determine what your recovery is. You usually have to submit medical records, and may have to undergo deposition testimony, provide information about your particular claim. But there are some Alabama attorneys that are doing that, so feel free to call in, or I will get back with you after the show and give you that information so you can sign up.
Why would he want a local attorney? Do you want to have a local person as well as the national firm, or how do you want to do that?
You want to have some
help?
Accountability. You want to have somebody you look in the
I want
eye.
a person.
Exactly.
I want somebody
and
I
so
can talk to.
When you're just a number, sometimes it's difficult. When you're talking about class actions, again, you're talking about a lot of class participants. Yes. But again, having a local attorney oftentimes is better. I tried a case in Tuscaloosa at the beginning of my career, and we had a ruling go against us, and the judge looked at me and said, "That's not what you get for not practicing in your own backyard." We got cooked a little bit, but that was antiquated. Didn't happen very often.
Cooking.
But at the same time, you want somebody you can sit down and talk with and go over your case and have some type of accountability, as opposed to just mail it in because you really don't have anyone to go to when you've got an issue with your case.
We've got Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, I own a condominium here in Huntsville, and about 8 years ago, the condo association illegally foreclosed on my unit and then sold the unit to someone. And we went to circuit court, and the circuit court judge said it was illegal and set aside the the foreclosure. Well, it turns out now, 8 years later, I've had another dispute with the condo association, and instead of suing me, they sued the person they had illegally deeded the property to, and without my knowing it, they received a judgment with an order of foreclosure on my unit without my even being able to go to court. Filed an ARCP 59 motion in the name of the person who they had as the defendant, but the judge denied it. Is there anything else I can do? Do I have to file a separate action to stop them from foreclosing, or something so that any purchaser is not an innocent purchaser for value?
All right, now we're going in Alabama Rules of Civil Procedure, and we're going in trying to get who the proper parties are. So basically, he won his suit against the condo association. They ended up suing the person who illegally, they claim, transferred the property to them. So if you're talking about chain of title, you got to go all the way as far back up the chain as you can to correct it. Sounds like he was a victim of, a poor title that was transferred to him. My question would he be a dispensable or independent dispensable party because he's down the line? Sounds like not. And so if they went up further up the chain and proved that the title was not transferred properly, then everybody after that would not be a bona fide purchaser.
Wow.
Now, do you have title insurance? What type of insurance do you have to cover you for something like that? That's something that I would definitely look into. I would think you should have been a party to that other case or provided notice of some type, but have to look into it further.
Interesting. Mm-hmm. Let's talk a little bit more about products liability. You just mentioned guns and whether there is some responsibility on behalf of the gun manufacturers. So when you've got injuries, you've got things like that, are you thinking there is a trend toward making gun manufacturers responsible? And there are a lot of folks out there, a lot of gun owners out there are not going to be in favor of that.
I think there's a trend, well, it depends on what side of the aisle you're on.
Right.
I think there's a trend going away from that we're seeing right now.
Okay.
And again, if the weapon or product is used for its intended purpose, then they're not liable. And so is an assault rifle for humans? Is it hunting or this? So let's say it malfunctions. I think we can all agree that if you buy a firearm and it malfunctions, injuring you if you were attempting to use it in accordance with the manufacturer's warnings and all those things, then they should be liable. There's even a slant away from even that of reasonable liability for a product that performs poorly and results in injury. And so if they place a gun or any other product in the stream of commerce and it's either defective in its design, manufacture, or the way that you instruct people to use it, then there are laws that they are liable under Alabama Extended Manufacturer Liability Doctrine.
Okay, let's talk a little bit about evidence and how evidence has changed over time. Car accidents, 18-wheeler accidents. Technology has made it, has it made it easier for you to prove your case or harder for you to prove your case?
You know, in some of the 18-wheeler cases, way back in the day, we used to have where they've got 2 sets of books. They're cooking the books. They've got 2 logs, and they're trying to figure, and everybody's running, and there's drugs involved in this. But now you got Qualcomm systems or some type of GPS systems that's managing the trucks, where they are, how fast they go on, how long has this driver been without sleep. So there's many different tools, if you will, that's ultimately made it safer, because the 18-wheeler wrecks were, they're still dangerous and deadly, but luckily they're not as many as there used to be, and a lot of that's the safeguards of technology coming into play.
They're telling us take a break. We're going to take a break. Be right back. It's Ask Us Anything night, so call in your questions. The number there, 536-0077. Be right back.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Dovia. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Dovey. Will League is here from Timberlake and League answering questions, and it's Ask Us Anything night, so we are taking questions on anything from car accidents to medical malpractice, and we've got callers waiting. Shavonda has got a question from Pulaski, Tennessee. Shavonda, thanks for calling. What's your question tonight?
Absolutely. So there's a property under contract that was hit by a tornado. Does the buyer have equitable title? And if so, are they entitled to the adjuster's claim report regarding the insurance claim?
Ooh, interesting.
Okay.
Got some
all right,
ideas
so
for
there's
her?
a contract pending. There hadn't been a closing, right?
No closing yet.
All right, so right now the buyer is not vested in the property. I mean, they may have the right to inspect and things like that, but it hadn't closed. But at the same time, on the other side, from the buyer's perspective, they probably had a contract for, did you say it was in a storm? What'd you say?
Tornado. Hit by a tornado.
And so they probably had a contract for a house that wasn't structurally inefficient. So I would think that an inspection would have to be done. There's ways to look at that particular inspection to determine whether or not that still complies with the original meeting of the minds of the original contract. Because I would imagine if the house was, you have the contract for a house that was standing, didn't have foundation issues, had a roof on it, whatever's going on. What's the damage to the house, do you know, or is that what we're really trying to find out?
It was probably about 7% of damage to the total price of the property. It was around a $450,000 home and maybe $30,000 worth of damage.
So is the buyer wanting out from under this deal? Or
no, they just want to see if they are able to request the proceeds from the insurance, or if they can even at this point just review the adjuster's report.
Gotcha.
Is closing pending?
Yes. So it's recently been extended, but they would really like to see that report or find out if they have the option to request the proceeds from the claim.
Well, okay, so you have another issue. You need the insurance. Is the insurance from owner A going transferable to owner B, or is that insurance contract extinguished? You need to find out that, and also look into. Again, if I was the buyer's representative, I think you should be entitled to that. But again, you might not be. But again, you can also have it inspected, and it may not again comply with the inspection. But again, you're talking about, that's a lot of, I'm saying that again. You're talking about a specific performance. So what if it was someone's home and you're trying to enforce that contract and the seller says, no, you've got a deal, and they could sue you to enforce that particular contract, depending on the provisions within the contract that give you either an out or approval of inspection or things like that. It may be too far depending on the wording of that particular agreement.
It's like law school tests. You always go, this cannot happen. All of these different things, this will never happen. Oh yes, this and more can happen. Things can go wrong. Dennis is on the line with a question from Albertville. Hi, Dennis. Thanks for calling. What's your question tonight?
Yes, ma'am. This is more or less of, I guess you call it medical malpractice.
Okay, what's happening?
Well, prior to Thanksgiving last year, I went in the doctor. I was running high fever and everything, and they did a MRI and said I had osteomyelitis in my middle toe on my left foot. And instead of docking the whole thing, to the base, they just knocked it to the first joint of my toe.
Okay.
And since then, that toe rubbed into my fourth toe, and it got an artery and caused that thing to turn black into rot. And I was set up for surgery to have it removed the Monday after Thanksgiving.
You mind me asking, are you diabetic?
I am, but it wasn't from diabetes. It was just osteomyelitis where my toe had got bumped.
So, Dennis, it would go back to whether or not the standard of care from the physician who treated your middle toe, was it the standard of care to go all the way back, or was it the standard of care going to the first joint, I think you said. So you would have to have an expert come in and testify that it was a breach of that standard of care to go to where that doctor particularly went with the treatment. But then you're going to have to also be able to show that that would not have happened through natural occurrences as well. So you have another hurdle that you'll have to get across to prove liability in this case.
He says diabetes didn't have anything to do with this. You're looking at things. What are you watching for?
The way they defend them is they want to try and find any pre-existing condition that would, in this case, that would contribute to poor blood flow to the joint or to the extremity. And so oftentimes when you've got diabetes or pre-existing conditions, it's easier to defend these cases. They say, look, it's a lot more likely that something bad's going to happen based on all these preconditions.
Yeah, interesting.
And so it makes them easier to defend. The diabetic cases are difficult when you've got lack of blood flow. They're so difficult to get there, and we've learned that over time.
We've got Johnny from Danville on the line. Johnny, thanks for calling. What's your question tonight?
Yes, I had a contract. I needed a construction worker. I have a slant in the kitchen corner, and they kept telling me I needed a foundation company. They did not do this. So I called the foundation company out. They came out. I begged them not to touch my house that has been standing since 1982. Nothing was wrong with but a 3/4 piece of plywood that was missing in this corner of my kitchen. They came out, jacked my house up, and now I've got to redo my whole home. And they will not come back and fix their problems. I've had a structural engineer come out and do a report. I've had a home inspection done, and they both said that it leads back to what they done, but I cannot get a lawyer.
Right, so let me
I can't even hire a contractor.
Right. So let me ask you this. You told them not to, they came out to do an inspection, and then you said don't touch the foundation, but they did it anyway?
They told me I needed jacks all up underneath my bedroom, up on one side of my house, and I told them, I said, that room has been sitting for 20 years. Please do not do anything to destroy my home. Please do not. I was in tears, actually, begging them not to.
Well, I'm still confused.
Is the only thing that needs to be done.
You did let them jack up some of the house.
They came in and said that I needed jacks or that room was going to fall.
But did you agree to, okay, you can do the jacks?
I asked them not to tear my home up, and they said, this is what I needed done.
Okay.
I said, if it needs to be done, please do, because they was doing moisture barrier and mold.
They're telling us we're almost running out of time. But here's the thing. Look at the contract again. The contract's probably going to give them permission to, if there's ancillary damage from the work, it probably waives their liability depending on the particular contract. Unfortunately, since you let them do the work, let's say you said don't touch my house and they did it, I think it's on them. but we're going to have to look at their contract to see, did they do it in an unprofessional manner, unworkmanlike manner? What was, how bad did they blow it? And did their contract give them an out for the work they performed, any ancillary damage? You'll have to look at that.
Okay, we had a caller call in. She didn't want to go on air. Some folks are just timid like that. She says her daughter got a root canal at the dentist, or at least got started there. It did not go well, and she wound up going to an oral surgeon, and I think it wound up eventually going to the ER with some problems with that. Okay, she would like to know, can she get her $1,500 back from the original dentist? It did not go the way she thought it would. Can you get your money back?
Sometimes the dentist will agree. If they agree, then yes. If not, you'd have to show that there was a breach of contract, but all claims against doctors go into the Medical Liability Act, which has to show there was a breach of standard of care, or if he violated that particular provision of the contract, you might be able to go there. It's difficult, but you should be able to go sit down and talk with the dentist and say, look, we paid for your root canal. It never happened, and here's all the other ancillary damage.
A $1,500 problem, is that something that most lawyers are probably not going to take something on with that kind of money, right?
Sadly, it's an economic issue that she would spend more money for
on the
lawyers
lawyer,
and trying to get an expert and all that than she recover. So it's a case that she probably shouldn't look at, couldn't go after.
Okay, we're going to take a break. Be right back answering more of your questions. It's Ask Us Anything night. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Will League. He is with Timberlake & League in Huntsville. They are personal injury attorneys, so that's everything from car accidents, medical malpractice, nursing home negligence, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And this one right here is family law attorney Sharon Doviet. 539-7337, child support, custody, divorce, SharonFamilyLaw.com.
It's tax time. We were asking, any kind of liabilities you face for not paying your taxes?
Yeah, it's criminally. I mean, there was a bill to, I think, hire a bunch more agents. I don't know if it had passed or not, but don't ignore it. File something saying, look, I'm working on it. Don't just ignore it, because that's when you can get in trouble.
Yeah. Thanks for all your calls. And well, we've got just a little time left. Arbitration. If you get a contract that says arbitration, do you run as fast as you can away from any kind of contract like that?
Where they really are sticking points is the nursing home. As we're aging, there's more and more nursing home negligence cases, and it usually comes down to staffing. But there's arbitration agreements, and that's to be very careful when you're going to a nursing home, because arbitration, again, you don't have a jury trial. Sometimes, that's debatable about whether that's good or bad, depending on what jurisdiction you're in, but it takes away that right, and they ask their arbitrator, and do you get a fair shake? It's not as level of playing field as a jury trial.
Think about it. Read those contracts. Thanks for all your questions tonight. Everybody stay safe and see you next week.